Oh, let's see what Lawrence Xu-Nan's going to say.
Mr. Chair, I just want to follow up from what the Minister has just said, and I do want to check in terms of the policy intent behind Section 18 of Part 2, because understandably, this is possibly have victims of family crime that is the focus here. But I do want to specify that Section 106 of the Sentencing Act specifically says that when you're looking at discharge without conviction, it amounts to an acquittal, which then begs the question of if we're giving these sort of protection orders to the people, but without any sort of subsequent guidance, what sort of advice has the minister received regarding that this is something that is actually beneficial to victims of family crime? Because one of the things that we do see when it comes to victims of family crime is the fact that often when, if not dealt carefully, in terms of conversations, education of the offender, we do actually see that things could possibly be worse. I get what the minister is saying, that again, it doesn't mean that the victim needs to make a separate application for protection order, but I wondered if that what we're doing here is a very much sort of last resort, bottom of the cliff kind of approach, whereas what we're not seeing here is what is actually beneficial for the victim and what is the tool that allows an offender in those circumstances to be aware and to be able to change their actions or change their perspective because of the fact that there is a guidance, there's sort of an education following on. So my question is sort of around the policy intent of this. Again, going through the department report, this is not an area that was discussed in detail, but like the previous speaker, the Honourable Dr. Duncan Webb said, it is reasonably significant because when you are acquitted from a crime, you are supposed to be able to have no potential punishment or repercussions as a result. And there are other factors that would then intervene in terms of from a borrower perspective as well, which also wasn't something that was explored in the Attorney General's report. So yeah, just want to get some clarity around if this was supposed to provide support and be beneficial to the victim, what is the evidential basis for that?
Honourable Ginny Anderson.
So the way I understand this is that for a Section 106 discharge without conviction, that means that in instances where there was no consequential sentencing or conviction on the record, you would still be able to have a protection order in place if the court thought so. And I would assume, and the Minister might want to clarify this because it leads into my question, that the judge would then be determining on the facts before them when that would apply in terms of a Section 106 discharge. So if the Minister could just give us an indication, because the whole kind of purpose of this bill appears to be to limit or curtail judicial discretion. So I'm just interested to understand why in this particular area he's okay with judicial discretion, because the proposed amendments in the Act and the combination of the implementation of three strikes, which has already been put in place, represent a really significant shift in the willingness of limiting judicial discretion and effectively restricting judges and having a prescriptive sentencing framework that makes sentencing less efficient. So I'm interested to know why there's this carve out here for Section 106 discharge without conviction, when the entire kind of ambit, the purpose of the bill is to strip away the discretion of judges. And I'd like to point out, Mr. Chair, I think it's important, and even the regulatory impact statement notes this, a fundamental problem with this approach is it limits the judge's ability to consider the circumstances particular to the case and to deliver an individualised sentence. And conversely, it really could be argued that a far more prescriptive approach to sentencing might have some benefits, and I'm sure you argue it, but how does he map out Section 106 discharges different to the rest of the bill, which puts significant limitations on judicial discretion? And he's been picked up by the Bora vet and saying that the existing framework has got real issues for when the judges are having the ability to look at what is before them and make an appropriate sentencing and a determination based on the facts before them. So in a nutshell, my question is, what's good for the goose should be good for the gander. Why is the Minister saying that it's fine to take power away from judges in one part of the bill, but in this part of the bill you're saying they're able to say, oh, you still get a protection order in place even if you've had a 106 discharge? We heard ex-select committee stakeholders quite clearly advise that limitations on judicial discretion have unintended consequences, and these risks do include legal challenges on procedural ground for breaches of Bill of Rights. A prescriptive approach can drive significant court delays, and we know the family court, which this would apply in this provision under 18 of Part 2, has already got significant delays in the system. So they have conflicts and big problems long term, and those delays we know plague our justice system. Officials have made it clear that they consider it important that just judicial discretion is maintained right across the various amendments in the bill. So it is unclear why this part in Part 2, 18, Rule 341B is different. Under this bill, the changes proposed, if implemented, has a really big impact on the ability of judges to weigh up the information before them, take into consideration the victim, the family, what's happening in these situations, and to be able to use the breadth of their knowledge and understanding of the law to make sure that there's an outcome that keeps communities safe, that reduce the chances of reoffending and also give fairness before the law. So I'm really interested to note why the Minister feels so strongly about curtailing judicial discretion, yet here in the Part 2 of the bill there is a specific, appears to be a carve-out for Section 106 discharge without conviction still being able to have a protection order in place, and that would be, in this instance, that would be at the discretion of the judge to determine when that would apply. So where is it okay for a judge to have some independent consideration, and when is it not?
Honourable Paul
I'll just respond briefly. This legislation doesn't change the threshold for granting of protection orders, and so we're not dealing with that. All it does is stops the need for a separate hearing on matters, so that it prevents victims having to have a separate application, which saves court time, which I think the member just said she was concerned about, and that is the purpose of this.
Okay.
And this is where I wish I was a lawyer, because half of that I didn't really understand.
I
not
would agree
familiar
with
with-
you. Like, all I know is discharge of protection order. That's what I gave it. Discharging a protection order, or no, was it discharge without conviction, but a protection order has been granted?
Yeah, I mean, there's not much commentary I can really offer there, because it's like, oh, okay, that's not generic stuff that I would be able to really understand as like protection orders and whatnot. I'm not familiar with that stuff.
Yeah.
So yeah, this is where I kind of.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok.